You have been warned. Good afternoon, everyone, and welcome to this Offshore Chambers seminar. Welcome to those watching online. A particular welcome to those who are here in person. So welcome and congratulations, because I'm told that the place is actually sold out within about 10 minutes, if sold out is the right expression for a free seminar. But having said that, I can see lots of empty spaces here. It is a nice day. We have some no-shows, so be it. I suggested to our marketing committee that we continue not to charge for our Chambers seminar, but we charge £100 for those who say they'll come along, and then don't. We're effectively stopping other people who might come along and do. And I was told, no, that would be impossible to enforce. Is that better? That's better. Yes. You should be able to hear me even without the amplification. It might help us who are watching online. Yes, I said we should charge a fee for those who say they'll come along in person, and then decide, no, I'm busy, I'll watch it online, or I won't watch it at all, or I'll speak to somebody else. So maybe afterwards, if you stay for drinks, I could take a sort of poll about that and see what people say. Is it enforceable? Is it a good idea? Is £350 enough to avoid the disappointment of those who might have come in person, had they not said, no, we'll have to be booked. Anyway, on to the subject of today. I'm often asked, what am I expecting in the budget? And I expect you are too. And I was right about the small point, which was Fisher. I said, Fisher is going to be reversed. It's going to be reversed in relation to all income arriving after beginning of the next tax year. And moving to Rory's topic, if he will forgive me if I boast the prediction which I correctly made. It wasn't a difficult prediction, because this is what happened after the taxpayer was successful in Willoughby. This is what happened after the taxpayer was successful in Vestey. So I predicted that, and I was right. I have to admit, I did not predict the non-domicile, which is the main focus of attention this afternoon. And out of curiosity, can I ask, did anyone in the audience predict what would happen? That is, at least before the rumours started flying the week before the budget. Did anyone see this coming? I see no hands up. Well, that makes me feel much better. But with hindsight, perhaps it was predictable, because it follows a long history of Tories adopting popular Labour policies. And the fact that it makes them money, or they think it's going to make them money, or at least they can say it's going to make them money and therefore proceed on that assumption, is an added bonus. So the Labour have been wanting to do something like this. They've made it perfectly plain. We would have had this seminar, if not this year, then after the election, assuming Labour get in, which seems more than likely. So maybe we shouldn't be surprised to be where we are today, although we all are. So be it. Anyway, I haven't yet said anything about the reforms, but I'm working through my notes, which you will have, and I hope those watching online will have. I'm not going to read them out, but I'm going to sort of run through them and comment on the points which interest me, in the hope that they interest you. And after all that, I have reached page 2. I have a heading, what information is available. Basically, you'll be looking at the technical note, which the Revenue have published. Some documents called technical notes are not very technical. This one is covers more technical detail than others. I guess the decision to proceed along these lines was made about 3 weeks ago. So they had a reasonable amount of time to get as far as they did in the analysis of what they want to do, except in relation to inheritance tax, where I guess the decision was made probably about 5 days ago, 5 days before the budget, and said, well, while we're about it, let's do this too. And they said, that's a good idea. And how should we do it? Well, we'll put all that out to consultation. So what we have to go on is the technical note. Nothing else is necessary to read at the minute. There's a bit in the budget, so-called budget statement, and so on. It only repeats what's in the technical note. But actually, you don't even have to read the technical note, because it would be sufficient, I think, to read the lecture notes which you get here from me and from Rory. And if you want, you can look online on the online version of my book, which I hope most people here do from time to time. And that has some discussion of the rules, and it will be updated from time to time as we get more details. I use the passive, it will be updated, because although I update it, it is also possible for you to update it. Any user of the registered user of the chapter can actually make changes. It's a little bit like Wikipedia in that respect. And I encourage you to, if it's only correcting a typo, typos are like weeds, they're always with us, they have to be eradicated and then more come along. Or if you have something more interesting and substantial to say, there's the opportunity to say it. And I do encourage you to do that. It hasn't been done, I have to say, quite as much as I would have liked, this updating facility, but now is a chance for anyone with a point to make, with time on their hands, wanting to do me a favour, to have their say. So I commend it to you. So that's what we are looking at. And when we look at it, I've reached the middle of page 2 of my notes. What do we read? We read a new regime for personal FIG. I don't know if I like this abbreviation, FIG. Do we call it FIG? Do we call it FIG? I mean, hands up, who calls it FIG? Yeah, the significant number of the audience. Foreign income and gains. I've tried to avoid it in my book. It is so convenient. I think I'll probably have to give way in the end. So, personal FIG, foreign income and gains, for 4 years will not be taxed if you haven't been in the UK, resident in the UK for 10 years before that. That is quite a revolution, isn't it, compared to what we have at the minute, which is a remittance basis for non-DOMs. It is different. I'm anticipating what I say a bit later in my notes. Where do I say it? I'm sure I say it somewhere. Yes, down at the bottom on page 4, but let's look at it now. The differences between what we will have and what we have at the moment. The FIG regime will apply is a complete exemption for all income gains. You can remit, unlike the remittance basis, which was a qualified exemption, only applied if you remit. On the other hand, the FIG regime only applied for 4 years, and the remittance basis applied at least until you became deemed domiciled, and maybe a little bit more, unless you actually became UK domicile. And there again, the new regime applies to those who haven't been here for 10 years, including, importantly, those who are UK domiciled. So who wins out of this reform? Actually, it's the UK domiciled. Somebody who went to Hong Kong, has been working there for 10 years and comes back, who never acquired a domicile in Hong Kong, would in the old days have become, when he came back here, become taxed on the horizon basis, will now be taxed for 4 years on the figure basis, namely he won't pay tax, or she, on their foreign income or foreign gains for the following 4 years. Big changes. We have a much more generous relief. We have a much less focused relief because it applies to non-DOM, UK DOMs and non-DOMs, but obviously in return for a much shorter period. What else follows from that? In terms of general tax planning, what used to happen until the rule, or will continue to happen next year until the rules change, was pre-arrival planning, wasn't it? Before somebody came to the UK, they took advice, or at least one hoped they took advice, and they said, I'm coming to the UK, ideally in the next tax year, please tell me what to do. And we would say, well, you can dispose of your gains, you can realise income, that will be a clean capital, you can remit it to the UK in the following years. This was the starting point for pre-arrival planning for foreign domiciliaries. If they were UK domiciliaries, then they would still try and realise income and gains, and they would be tax-free as long as they did it when they were non-resident, subject only to our temporary residence rules, temporary non-residence rules, I should say. Anyway, how's that changing? We are going to move into a world, I mean, of year 4 planning. Our clients, it's much better for clients who don't actually think about tax before they come here, of whom there are some. Because they can come here for 3 or 4 years to enjoy the benefit of the FIG basis. And at that stage, in their last tax-free year, or FIG-free year, I think I can get used to FIG actually. In their last FIG-free year, then they must realise their gains, while they're still foreign gains, while they're still tax-free. Just as at the minute, ideally people would realise their gains before they came here. Then they should realise their foreign income while it's still tax-free. And although they're then going to move into a regime where they are fully taxable, they may be able to live off that income, those income and gains for quite some time, particularly if assets are held through a company structure, particularly if it's a company structure not within the scope of the Section 720 because perhaps of the motive defence. So that's how things will change, unless we have some sort of forestalling provision. Will we have forestalling provisions? Well, no, don't ask me, I have no idea. In my book, I basically try and write the law, as it is. And I try and avoid sometimes giving things away because it's such an obvious thing. I don't want to sort of encourage our Parliament in its wisdom to introduce these rules. So I don't say it's all subject to these forestalling rules, but I can say it here, I can say it online. One of the risks of this sort of planning is forestalling. So should we perhaps be realising our gains now in our plans? For our plans. Well, if we realise them this year or next year, it'll be taxed on the remittance basis before the new regime comes in. That may not be a bad thing because then we get the benefit of the transitional relief, which Rory is talking about. Or we may wait at least until the early stages, which would be better. Time will tell. I think I would probably wait in that case, except for those who won't qualify for the new regime who might want to realise their income and gains now. Anyway, what else have I got down here? Life insurance might be attractive because if you can realise the gain of the policy when you're going on resident. Offshore funds actually will also do it. It doesn't have to be life insurance. And the only thing to think about with those sorts of things, this style of investment really is costs. That is what would it cost you to hold your investments through that sort of structure. Double taxation relief. I was talking to a delegate about this just outside. He said, yes, what will be the position? He said, in relation to someone who is here, qualifies for the figure regime, doesn't pay tax on their foreign income and gains, but the income and gains may be subject to foreign tax, which under the treaty, you might be able to reclaim. Will that be the position? The first thing, and I say, well, that's a very good question, and I'll address it in the lecture, so I didn't answer it, but I will try and answer it now. I won't answer it even now, for various reasons. One reason is, it's not a UK question, is it? It's a question, if it's going to get that tax back, which has been deducted at source in some foreign state, it'll be the foreign state you're asking to make the repayment. It'll be the foreign revenue which decides, and the foreign courts, if you litigate, which decide the point. Secondly, like everything, it does depend on exactly how the rules turn out. But I will only say that there may be a difficulty here, mightn't there, because you will have to show that you are a resident of the UK for the purposes of the treaty. And as I set out in my notes, at least, yes, I've reached page 3 of my notes. I could have to speed up a bit. I was telling our speakers I insist on keeping to time. Look, I should say I insist on other people keeping to time. Here we have it at the top of page 3. Resident doesn't include someone who's only liable to tax in respect of income and gain in the UK, in respect of income and gains in the UK, and that's exactly the position, isn't it? That's exactly the position of somebody who qualifies for figure relief. So then we say, well, does the treaty mean what it says? And treaties don't always mean what they say. And there may be arguments around that, but that's as far as I will say, because I think we'll need to return to that question when we have the final rules. Counting years, it's difficult to count to 10, at least I find it difficult to count to 10. So I've set out in the notes how I think the 10-year rule will work. If we have a client who was last in the UK in 1415 and comes to the UK not this year, which would not be that, but next year, or rather not next year, but the year after, then he or she will qualify for the relief. How do we count years? We use the SRT. The good thing about the SRT is, by and large, we know whether somebody is resident or not. There are sometimes questions. We have, for instance, the question of whether or not you come within the exceptional circumstances defence, which was discussed in my case on that. And I have a little bit of intelligence for that because I discovered just this afternoon we have permission to go to the Court of Appeal in that. So if you are following with interest a case called, under the anonymous name, A Taxpayer, the HMRC, to do with somebody who overstayed owing to exceptional circumstances beyond her control, or rather what the FTT held were exceptional circumstances beyond her control and the upper tribunal held weren't. We will wait and see what the Court of Appeal will have to say about that in due course. And that, I think, is very good news, not only for council, who have the pleasure of affecting the Court of Appeal, but for taxpayers generally, after a rather harsh decision, I would say, of the upper tribunal. Anyway, so we apply the SRT. We ignore split years, they count as full years. That's not a surprise, it's the same when you're counting years for deemed domicile, say. And we ignore treaty residents. And this is something to bear in mind, because I don't think clients who don't understand tax will realise that. I can be UK resident and I can be Danish resident. I may be Danish resident under the treaty because, although I'm resident in both places, that may be where I have my permanent home, but available to me. But I will still count as UK resident for the purposes of FIG relief. So that's an important point to bear it in mind. What else? Well, we have to make a claim. That's not very difficult. The only question about claims, I think, is whether we will have to say when we make the claim how much money foreign income and gains we have. We don't when we make remittance basis claims, do we? We don't have to say in our client's return, I claim the remittance basis, and this is the amount of my unremitted foreign income and gains. So I guess it's going to be the same here. And what will follow from that is we will never know exactly how much this relief costs, because you will have to guess as to what those foreign income and gains might be. But it might be the other way around. We'll have to wait and see. You lose your entitlement to a personal allowance, well, that's not a lot. Although if you have a marginal case, you'll need to do a computation. You lose your entitlement if you make the claim to your capital gains tax annual exemption. That is even less. Now it's coming down. Is it 6,000 this year, 3,000 next year? I think. So we can forget about that. It's not important. You can come here after 10 years, go away for a year, come back. You'll get relief for the 4 years. Those are the 4 years in which you are here, and that is an outline of the relief. Let's move on and look at offshore trusts. I've reached page 5 of my notes. What we have from the technical note. For 4 years, you're going to be fine. You're not going to be taxed on income within the structure, the trust or the structure. Under the various anti-avoidance provisions, you're not going to be taxed on the gains within the structure, under the various anti-avoidance provisions, section 86, section 720, section 624. And then after that you are, and there's a comment here about the treatment, the way that foreign income will continue to be treated, old income, as relevant for relevant income, or for section 731, and so on. I put down here the best course may sometimes be to wind up the trust after 4 years, or perhaps wind up the trust within 4 years. But there'll be a lot of thinking around that question. A lot will depend, I think, won't it, on how the anti-avoidance provisions will work in any particular structure. If we have a trust holding an offshore trust, and it has income or gains, those will come into charge to tax after 4 years, if the settlor is here. On the other hand, if we have the trust holding a company to which the income and gains arise, what would happen then? Well, until now, we haven't really cared about what happened, because there would be a protected trust and we knew where we were. But suddenly it's going to lose its protection when these new rules kick in. And we will care, and we will be asking questions like the motor defence for transfers of assets. Will that apply? Because if it doesn't, our client is probably stuffed, might even consider leaving the UK. If it does, it may not be badly affected by these rules. And likewise, the motive defence for capital gains tax in section 3 of the TCGA. Will that apply or not to gains occurring within the structure? And these questions, which we haven't had to consider, we will have to consider again. Transitional reliefs, I didn't have to talk about because Rory is covering that. Overseas workday relief, this is a slight varying from the usual rules. When does it apply? It applies to minute non-doms in their first 3 years of UK residence. And at the minute it says we will apply the remittance basis to that part of their employment income which is in respect of duties performed outside the UK. And going forward, it'll qualify for something like fig relief. It won't, the income attributable to duties outside the UK won't be taxed at all. In this case, for 3 years, not for 4 years, which was inconsistent with fig relief, but it is consistent with what we do at the moment. And it'll apply to a variant really of fig relief applying for employment income. Now we come to the biggest surprise really of the paper. The rest, had it been a Labour paper, you might have guessed how it would go. I don't think you would guess the transitional rules, but you might guess something like the fig relief. I wouldn't have seen the domicile reform coming. But there we are, it has come. It's not a remittance basis point, and what Labour said they would do is abolish the remittance basis. Our government have gone a bit further, and they haven't completely abolished domicile, but going forward, it'll play a much smaller part in all our lives. So for inheritance tax, the current position being for one's own property, if I'm domiciled in the UK, I pay tax, and within the scope of tax for all my property. If I'm non-dom, only for my UK situate property, or possibly foreign companies which own UK situate residences. And that is going to change for a 10-year test. So once I've been here for 10 years, I'm within the scope of inheritance tax. Conversely, if I leave for 10 years, I'm outside the scope of inheritance tax. Well, there's an incentive to go if you need one. 10 years is quite a long time. Don't leave it too late, I suppose, is the advice we must give our clients. We may get the spouse exemption, in which case one's looking for 10 years on the death of the survivor of husband and wife. If I've been here for 9 years, I might seriously consider going or going sooner while I'm still outside the scope of IHT. But it depends really how serious a threat IHT is to me, isn't it? If I'm 50 and in good health, I could go away and expect to survive 10 years. I don't really care if I'd come within the net and fall out of it again. And the main burden, I think, will be complying with our rules during that 10-year period when I'm within the scope of tax, not to make chargeable transfers by making gifts to trusts. Bearing in mind, if I make pets, they will only be potentially exempt. Or I can just wait. I could take out insurance if I want, or I could self-insure and say, well, actuarially, the risk of death for me is not all that great. I can put up with it. Another client in poor health or extremely elderly, it'll be a completely different assessment. We'll need to think about the IHT spouse exemption. That may operate differently because at the minute I get the relief, don't have to make a gift to my spouse unless I'm UK domiciled and she's non-dom, because I don't get the relief unless she makes the election, which has various costs associated with it. We will probably have something like that, except we'll be applying 10-year tests and not domicile tests. You may want to make your gift next year before the new rules kick in, when we know what the new rules are, or when we have slightly more idea what the new rules are. Because you can imagine situations where interspouse gifts at the minute are tax-free, which will cease to be tax-free once the new rules kick in. Or it could work the other way around, of course. So that'll be something to think about. Then we move on to trusts. Good news for pre-2005 trusts is they will qualify under the existing regime. They will be IHT exempt if the settlor is non-dom and not deemed dom at the time they make the settlement. And that will continue even if they subsequently become deemed domiciled, or if they subsequently become 10-year residents within the scope of tax. Conversely, for new trusts made after the new rules kick in, even if the settlor is outside the scope of IHT when he makes the gift, if he stays here for 10 years, it seems that the trust will come into charge. And if he goes, it will remain within charge for 10 years. So you'll be facing perhaps at least one 10-year charge. How will that affect our clients? It will vary very much from one client to another. It could be quite an expensive business, that. So there's something to think about. What do? We probably want to make trusts next year, don't we? Well, they're still under the current regime. I think you could do it now in the hope that if forestalling provisions come in, you get in first. Or you might wait and see what the rules are and do it then. But chances are you'll be ahead if you make your gifts to trust now, rather than waiting till later, if you're going to come within the 10-year regime. We'll be asking our clients, are you going to be here for 10 years? If they shrug their shoulders, you can say, well, if you are, then this is what you're facing. And if you go, then that's what you'll be facing. They may say, well, in that case, I'll go. Well, that solves the problem if they do, I suppose. That's where we are with that. Yes, what else? We've got formerly domiciled residents, those who were born here, domiciled here, and left and come back. There are not that many of them, but there are some. They are ungenerously treated under the current regime. I wouldn't expect it to get any better. So, moving on to page 9 of my notes, consultation questions. There's just a list of things I haven't thought about yet, but at least I've noticed that they haven't thought about them. So that's something. Length of the residence criteria. Well, they say 10 years, but it could be anything. Length of the tail provisions, likewise. This is interesting. Connecting factors other than residence. What's that getting at? What's that getting at? But it can't be domicile, because we all know domicile is an outmoded concept. So it has to be citizenship, doesn't it? That would be my guess. We'll have citizenship thrown into the mix for connecting factors, but we shall see. We shall see. And much, much more. I've written down here a question we haven't asked yet, although they will need to. What about our double taxation agreements? We have, I think, 10 inheritance tax double taxation agreements. That's not much of the world is covered, but the ones that we have are important. They'll probably have to be renegotiated. That will take a few years. The most interesting of those is the one with the ones with Pakistan and India, particularly India, which apply rather generously, because they say if you're Indian domiciled, then you don't pay tax here, which made sense when the treaty came in the 50s, because India had an estate duty. All the former Commonwealth countries had an estate duty, and most of them have, or perhaps all of them, have abolished it. And in India, they abolished their estate tax, but they didn't abolish the treaty, so we still get the relief. It's an absurd rule. And the challenge for our clients really is, can I rely on it? Because what they need to say is, will that rule still be in existence when I die? And there's always been a question mark over that. One sort of unexpected consequence of these reforms might be that question is looked at. But then who knows, because we're trying to negotiate a trade treaty with India. And one of the things we might give quietly in order to get that trade treaty is, okay, you can keep your estate duty agreement. And that might explain why it survives as long as it has. I don't know. Speculation. Good, that gives me 5 minutes to talk about the amounts raised and policy issues, and I've reached page 10 of my notes. I always like to put in a joke in my lectures. So here you have it on page 10. These reforms will bring in no money in 24-25. That's fair enough, because the reforms didn't actually take effect. 185 million in the first year, 2.8 billion in the next, 3.6 billion in the next, then going down for reasons which I find slightly strange to 2.7. Various points about this. When we had the figures for the 2017 reforms, I actually did a freedom of information request and say, can you please show me the working, how you got these figures? And they wrote back saying, no, we won't. And I couldn't be bothered to fight it. I'm not even sure if I was entitled to fight it under the Freedom of Information Act, so I just let it drop. I'm sure you'll get the same response now if you ask the question. The fact that they don't want to show the working well suggests to me that they're not completely confident in it. That's my first point. The second is the precision is just absurd, down to the last 5 million, I ask you. Suspicious in itself. I mean, it would be accurate, so it would be better to give a figure within 500 million than 5 million as to what the yield might be. But if we ignore that, then can these figures possibly be right? And I would say not. because the Warwick paper, Aaron Advane, nice guy, I know him, economist, looked at non-doms. He said if we abolished the remittance basis and did not bring in any short-term residence relief, it would bring in 3.2 billion. That was his estimate. And subsequently to that paper, I met him and he said he thought that figure would have to be brought down a little bit because he advised when he wrote the paper on the basis of revenue data given to him in relation to, I think, the first year of after the reforms of 2017. And then he had the next year's data and he qualified his estimate. Well, if complete abolition of the remittance basis brings in 3 billion, then complete abolition of the remittance basis, along with relief for foreign income and gains, is not going to bring in 3 billion. So I do think these figures are probably nonsensical. But you may say this is an interesting but entirely academic issue, and up to a point you would be right. If we are practitioners, we just want to work out what the rules are. But it might be relevant only to this extent, that if we're talking about what reforms will come in the future, future Labour government, if I'm right and they've underestimated the cost of fig relief, what we can expect is restrictions on fig relief. And I would tell our clients, if they're planning to come here on the basis of the relief, the risks they take, not only that the rules may change before they take effect in 2025, but in the following year or two, within the next 4 years, there may be further changes. What those changes might be, well, that's a matter of speculation. We might get a sort of forfeit charge, like the remittance basis claim charge for 30, 60, maybe 90,000, something like that. That wouldn't surprise me in the least. For the wealthiest of clients, the sort of oligarchs and so on, that's just small change anyway, so they won't care about that. But it will restrict the relief to the wealthiest. Whereas the striking thing about the current one is it's not restricted at all. The only cost of claiming relief is the trivial one of losing your annual exemptions. The figures are complicated by the transitional reliefs, which may spoil the figures. But the transitional reliefs are not going to bring in money, they're going to cost money. So they might bring in money in the years they apply, they're going to lose this money in the other year. What else have I got here? Comments about tax competitiveness. I think in the time available, I'll leave you to read that at leisure. Comments about simplicity. The new rules are said to be simple. The trouble with simplicity is that it is actually very complicated. I wrote multifaceted in my notes, but actually complicated is maybe a better word, because although we simplify things, I mean, the remittance basis was terribly complicated, made worse by mistakes in the 2008, 2017 rules, like the rules about mixed funds, which weren't so much complicated as ridiculous. But we will get rid of all that, or will we? Well, we won't, because we keep it all for existing remittances. We have not abolished the remittance basis. We have prospectively abolished the remittance basis. We haven't abolished domicile for inheritance tax. We have prospectively, or proposed prospectively to abolish it. We keep all that for the past. And then we have the added complication that losing protected trusts means, as I said, we will need to review offshore trusts and think about issues like the motor defence, which until now we haven't done. So yes, it is simpler, but it is simpler in a rather complicated way. And what have I got here about uncertainties? How many will come, how many will say, well, that's anyone's guess. We may know in 10 years' time. An interesting comment, it hadn't occurred to me, so I attribute it to Mullan, who wrote it. Is anyone here from Mullan's? Oh, good. Well, thank you for your paper. I did enjoy reading it, along with one or two others, but it was definitely one of the best. This point, which hadn't occurred to me, or which I didn't know, is certainly great for foreigners looking to realise their capital sales on foreign assets. They'll come here and they'll sell. They won't pay tax here. Whether or not they pay tax in their home jurisdiction depends, obviously, on the rules of their home jurisdiction. It won't help the Americans, but nothing helps Americans. They may have short-term non-residence rules like we have, but in principle, that might be a good source of business, if not a good source of revenue for the country. And big uncertainty is what will future governments do. One thing I would not expect is stability, because we have never had stability in the UK. all the commentators who look at it for decades have commented as to how unstable the UK regime is. They were commenting on this in the 90s and in the noughts and the tens. In the last few years, we had the reforms of 2008, non-dom reforms. We had the non-dom reforms of 2017. So it would be astonishing to think, although at the beginning of my notes, I set out 10 years of how relief will work. Don't I? It would be astonishing. I would be astonished if, yes, on page 3 of my notes, I set out the rules up to 2034. I would be astonished if the rules are still in anything like their current form in 2034. So as far as stability is concerned, I think we have to be gloomy. The other certain prediction I make is lobbying. And again, yes, it was McFarlane who kicked off. There will be much more on the lobbying. 4 years, they say that's not very long. Can't we have more? I don't know how many more. Ask for 10 and maybe we'll get 6. That's what lobbying will happen. Whether or not it gets anywhere, only time will tell. Good. I told that my fellow speakers that we were going to keep to time. Looking at my watch, I'm actually 1 minute late, but that's okay. Probably started 1 minute late. So I can pass you on to Rory talking about transitional rules. Oh, and Fisher, of course, and no one better.
Yes, it is. Sorry. Yes, so I'm going to talk about the transitional provisions which we have brought in relation to foreign income and gains, which I am going to call FIG, which arose basically before 25-26, whenever these changes are intended to take effect, and also look at the draft legislation which we have in relation to the amendments to the transfer of assets abroad legislation in response to the revenues loss in the Fisher case. Before getting into the detail of what the transitional provisions are, I think just to pick up a point which James finished off on there, and that is the fact that there are quite a lot of uncertainties here. Obviously, we don't have draft legislation. We're told that there will be some sort of technical consultation, and undoubtedly, as that takes place, some of the difficulties which arise or might be seen to arise will come to the fore and may lead to some changes being made. But also, these changes are intended to take effect from April 2025. The latest date at which we can have an election is the 28th of January 2025, apparently, which means that these changes are going to definitely take effect after the next election. Based on current polling, it seems likely that it will be a different government under which these changes take effect. And although there is some sort of consensus on abolishing the current non-dom rules, I'm not sure if we can really say that there's a consensus on what the detail will be and what type of transitional provisions a Labour government would like to look at. There are different considerations in terms of what changes hope to achieve. And I think in my notes, I pointed out 3, the sort of fairness, that basically all UK residents should be taxed in the same way. There may be differing views on that between the different parties. Encouraging investment into the UK, again, that's something which the regime might do, but again, different views. And finally, the idea that the tax regime should be simple and understandable. And as James says, but it has the benefit of some simplicity. Changing is not straightforward, and so there are going to be complications there. And then again, there will be different views. I suppose one benefit of the changes is that they will be understandable, and I think one of the problems with the current foreign domiciliary regime is that people generally don't seem to understand it, other than that it must be a bad thing and we ought to get rid of it, which is why we are where we are and why the Conservatives stole the Labour policy. I think looking at these changes, we have to bear this very much in mind. And I think the transitional provisions in particular are an area where there could be considerable differences of opinion, and there could be changes made in relation to what the legislation, what the law looks like by the time we get to 2025, 2026. And while absent a crystal ball, we can't tell what that will be. I think it is an important point, and one to be borne in mind in advising our clients that nice as it would be to expect certainty, there is a risk that we won't have it. So with that, sorry, I've missed a few slides, but with that sort of slightly gloomy introduction, let's look at what the changes are. So the first one, FIG arising to individuals before 2025-26. And we're told that FIG which has arisen to an individual in respect of which a remittance basis claim was made will be continued to be subject to the remittance basis. That means it will be subject to tax if it's remitted on or after the 6th of April 2025 in the same way, albeit subject to a temporary repatriation facility, which I'll go on to talk about. Things like business investment relief will continue to be available for qualifying investments of FIG, and that's apparently going to be the case in relation to investments made after 6th of April 2025 as well. And alongside this, relief will continue to apply to existing investments. No mentions is made in the technical note about other reliefs, but it would seem likely, consistent with that, that they will continue to apply, and that effectively we'll have the same remittance rules for some years going forward in relation to FIG, which arose before 2025-26, certainly for individuals. Which then brings us on to FIG arising within trusts. Well, that is now going to be subject to tax in a different way. It's going to be taxed on settlers or beneficiaries if matched to benefits provided to them from the trust. So it remains trust income. If there's a benefit provided, which it's matched to, then it will be taxed under the relevant provisions in the same way as it currently is. Unless unless the recipient of the benefit is within the 4-year FIG regime, i.e. UK resident, but only within 4 years and qualifying for the exemption. In that case, we're told that there will be an amendment to the onwards gifts rules, and so a modified onward gifts rule, so effectively to prevent distributions out to a qualifying beneficiary who then makes onward gifts. Will be introduced. Where the recipient of the benefit isn't within the 4-year FIG regime, then any benefit received will be taxable. Obvious difference being that that will be regardless of where the benefit is received. That's to say, and obviously the remittance basis isn't going to apply to relieve a charge in the same way it currently is. So what that does mean is that subject to any forestalling rules, as James mentioned, they might be introduced. It might be a reason for distributing distributions which qualify for the remittance basis before 2025, 2026, because they can obviously be enjoyed after that date outside the UK without a charge applying. And in that context, there is a linkage between the rules applying to trusts and the rules applying to individuals, and consideration needs to be given as to which is the best way forward. And that said, distributions out of trusts, obviously you also have to consider what's going to happen with inheritance tax in relation to property within trusts, and a consideration of how beneficial it's going to be to keep the trust going. And which brings me on then to the temporary repatriation facility. What we're currently told is that this is going to be a one-off relief in the form of a new 12% rate of tax for remittances of certain foreign income gains made in tax years 2025-26 and 2026-27. As I say, it's referred to as a temporary repatriation facility, and the purpose would seem to be to encourage remittance of FIG, which is currently held offshore, and it may also offer some encouragement to foreign domicilaries to stay in the UK, notwithstanding the loss of the current regime. Now, in terms of how it will apply, the technical note states that this will only apply where the FIG arose to the individual personally in a year when the individual was taxed on the remittance basis and resident in the UK. Now, this would seem to exclude FIG, which is deemed to arise to the individual, for example, under Section 735 of the Income Tax Act, so where you have a benefit which is matched to relevant income within a trust. That would appear not to qualify for this relief, although I think that's an area in which we could do with some clarification. That being the case, however, I think care should be taken with such FIG to identify where it is as compared to FIG which arises to a taxpayer personally, because it does look like going forward the two may be treated differently. And certainly the cautious view would be that that's what the rules are going to do. Although, as I say, we need to see the detail. The technical rule also makes a reference to a relaxation of mixed fund ordering rules, so as to make it easier for individuals to take advantage of the temporary repatriation facility. The examples they give are FIG in a mixed fund, or where the taxpayer is unable to precisely identify the quantum of the FIG. This is presumably a recognition that compliance with those complicated rules could be a barrier to bringing assets into the UK, and by simplifying it along with the 12% rate, they want to encourage people to do just that. In terms of revenues, we're told that it's going to result in an extra 15 billion coming into the country, raising an extra billion in additional tax receipts, and 12% of 15 billion, as you'll know, is not 1 billion, it's 1.8. The missing money presumably reflects double taxation relief, which, where available, may mean an effective 0% rate. So that's the temporary repatriation facility. The next transitional relief is a reduction in income subject to tax in the first year, 2025-26. And what we're told is that individuals who move from the remittance basis to the arising basis on the 6th of April 2025 and are not eligible for this new 4-year FIG regime will, for that year only, 2025-26, pay tax on 50%, only 50% of their foreign income. It applies to foreign income only, doesn't apply to foreign chargeable gains, and for 2026-27 onwards, it's back to taxing on all foreign income on an arising basis. In terms of capital gains tax, there is a rebasing relief for disposals made after 2025-26. It's rebasing back to the 5th of April 2019, and that will apply where you have an individual who has firstly claimed the remittance basis, secondly was neither UK domicile nor UK deemed domicile by the 5th of April 2025, thirdly disposes of personally held foreign asset after the 5th of April 2025, and fourthly, that asset was held by them on the 5th of April 2019, and we're told that an election needs to be made for this rebasing to apply. So those are the rules and the transitional provisions in relation to income tax and capital gains. Inheritance tax, we're not told very much. The one thing which we are told, whether it's a transitional provision or not, is that property within a settlement which was excluded property before the 6th of April 2025 will effectively remain excluded property. Obviously, it appears to be the intention that if property is held individually, then it won't remain excluded property. But as I say, there ought to be a consultation on that, and we will see further detail on it, no doubt, in the future. So that really covers sort of what the various transitional rules are. As I say, whether we can say with any confidence that they will still be there when 5th of April 2025 comes around, I don't know, but at the very least we know what's been proposed for now. So having looked at that and having been a bit sparse on the detail because we don't actually have any legislation, I want to look at the changes to the Transfer of Assets Abroad Code, where we do actually have some legislation. Clause 22 of the Finance Number 2 Bill 2024. Now, I should say I've set out all of Clause 22 at the end of the notes, if you want to have a sort of deep read through it, and I've put extracts from it as we go throughout the notes. So That contains provisions amending the Transfer of Assets Abroad Code, where a transfer is made by a closed company. The explanatory notes explain that it's about preventing, effectively, individuals using companies to make transfer of assets abroad. And what it said is that it's closing a loophole in the Transfer of Assets Abroad provisions. That does rather give the impression that the legislation is aimed at preventing a company being used as a device to transfer assets overseas, thereby avoiding the application of the Transfer of Assets Abroad provisions. I think they go rather wider than that, and you might think that we already have something in there to prevent a company being used as a device in that way, in the form of the associated operations provisions. And I think one of the interesting points about this new provision when it's introduced is how that impacts and how that interacts on the way in which the associated operations provisions would apply in the context of a transfer by a company, in circumstances particularly where Parliament will now have legislated to say, well, actually, that transfer by the company shouldn't be within the scope of the Transfer of Assets Abroad provisions. One thing the explanatory note doesn't make reference to is the Fisher case, which you might think is surprising, given that the legislation looks to be really quite focused on reversing the effect of that case. And while it's picked up some of the issues which were identified with applying Transfer of Assets Abroad provisions to companies in that case, it hasn't picked up all of them. Now, Fisher, just to give a brief overview, was concerned with the sale of a telebetting business by one company, Stan James Abingdon, to another company, Stan James Gibraltar, for a market value consideration. This all took place back in the year 2000, and both companies were owned by 4 members of the Fisher family. The reason for the sale was that the UK telebetting market had been disrupted by a competitor effectively setting up abroad, which meant that he didn't have to charge betting duty. That was a huge advantage compared to all the other betting companies. And so Stan James, like every other betting company, decided, well, we can't compete, and they all moved offshore and started offering telebetting offshore. Unfortunately for the Fishers, they were assessed a tax on the income of the offshore company. And I think one of the problems, and certainly one of the great unfairnesses as they saw it, was that every betting company in the industry had done exactly the same thing for exactly the same reasons, but they were the only ones who were penalised by being taxed on the income of the offshore company, the only shareholders. The Revenue had argued that although the sale was by a company, effectively it could be attributed under the Transfer of Assets Abroad provisions to the shareholders, being the 3 Fishers who were UK resident. And because SJA, Stan James Abingdon, was a long-established company, there's no question of there being a transfer into it, followed by an associated operation. The transfer, which had actually been made and had actually been made, was by that company, and it was that transfer which was the concern for the various courts. Then last, I think it was in November, we had a decision of the Supreme Court, which basically said, and I think went further than had been argued or even expected, that the Transfer of Assets Abroad Code effectively doesn't apply to a transfer which is made by a company. It only applies to a transfer which is made by an individual. That's what had been effectively held in Vesti, and they said Vesti continues to be correct. And whenever you look at a company, and I think possibly recognising a number of difficulties that companies are not synonymous with their shareholders, it didn't apply to a company at all. And that I've set out that the relevant quote from paragraph 55 of Lee Bruce's judgment effectively meant that the Transfer of Assets Abroad provisions didn't apply, and on that basis, the Fishers succeeded in their appeal. And that's context of this new legislation, because what it does is it introduces a new section 720A and a new section 727A, which says that the charge under section 720 applies for the purposes of preventing the avoiding of a liability to taxation by means of a relevant transfer carried out by a closely held company in which an individual has a qualifying interest. How that interacts with sections 720 and 721 isn't entirely clear, which, as we know, they're not the most easily understood provisions themselves. and how that particular provision applies in relation to them is less than obvious. I think what they're trying to do, and I suspect this would have to be the proper construction, is that those provisions apply as if references to the individual in those sections are references to an individual with a qualifying interest under section 720. But what that also does seem to mean is that an individual with a qualifying interest, regardless of the size of that interest, is going to be liable in respect of 100% of the income arising as a result of the transfer by the company. So you have a 25% interest in this company, the company transfers an asset abroad, section 720A applies, and despite that you only had an indirect 25% interest in the assets, you're liable in respect of 100% of the income. And that was one of the issues in Fisher. I said, well, this is one of the reasons why this can't apply. It's all very unfair. The Revenue said, well, the answer to that is in section 743 of the Income Tax Act, which allows us to make an apportionment. And presumably the reason why we don't have any apportionment provision in this new legislation is because they continue to hold to that view. I think that's problematic because it does seem to me that section 743 doesn't quite get you there. In terms of the various definitions, we have a closely held company. Close company has the same familiar meaning from section 439 of the Corporation Tax Act 2010. Applies also to a non-resident company. Then we also have a term qualifying interest. And you have a qualifying interest if you're a participator in a closely held company or one among a chain of closely held companies. A participator again takes its provision, its meaning from section 454 of the Corporation Tax Act 2010. We then get on to the conditions for application, where I think it probably gets a bit more interesting. So in addition to the basic conditions that the transfer is by a closely held company in which an individual has a qualifying interest, there are two further conditions or possibly defences. Firstly, there must be involvement in the company, which I've referred to in the notes, so the involvement condition. And secondly, there must be avoidance, what's referred to as the avoidance condition. And these, I think, will be the primary means in which a person who would otherwise be within the scope of transfer of assets abroad, provisions as a result of being a shareholder in a closely held company, may be able to say, well, actually, it should not apply to me. So firstly, the involvement condition, being involved in the company. And there we can see an individual with a qualifying interest in a company is to be treated as being involved in the company unless the individual satisfies an officer of revenue and customs that neither the individual nor, in the case where the individual is not the relevant participator, the relevant participator has any direct or indirect involvement in the decision-making of the company. So it's involvement in the decision-making of the company directly or indirectly. Now, that seems sort of relatively straightforward. But while you might think that we're looking at the decision-making in relation to the relevant transfer, which is engaging all these provisions, that's not what it says. It just talks about involvement in the decision-making of the company. And so that raises a number of further questions. When should the involvement take place? Now, it seems extreme to suggest that any involvement ever in a decision of the company is going to mean that you're involved in the company for the purposes of this provision. And what, for example, if you were actively involved, but you've since retired and you've got nothing to do with the company going forward, does that mean that once involved, forever involved? And secondly, what level of involvement is required? So if you approve the annual accounts as a shareholder, does that mean that you're involved in the decisions of the company? Or is it looking at something which is slightly more active? You would have thought so, but the problem is the vagueness of the legislation leaves quite a lot of this open to question. And the position, I'd say, is further complicated by what seems to be an anti-avoidance provision. It says any arrangements to secure that a person has no direct or indirect involvement in the decision-making of a company are to be disregarded if the main purpose or one of the main purposes of the arrangements is to secure that the condition in subsection 2A is not met. On one view, this means that if you say, well, I'm having nothing to do with that company because I don't want to be hit with a giant tax charge, that as an arrangement to make sure that you're not caught because you've deliberately not been involved in the decision making. But query, what is the effect of that arrangement being disregarded? Now, presumably what they meant to say was that the condition is regarded as not being met if those arrangements are in place. But what it actually says is that they're to be disregarded. So what happens if you disregard the decision? It seems to me not very much, because you're still left with the question of, well, is this person involved in the decision making of the company? Well, if you disregard the decision not to be involved in the first place, query how you do that. But it doesn't follow that suddenly they are involved in the decision making of the company. And I think obviously it's a drafting error, but it does rather suggest that maybe there's been less thought given to this than one might have hoped. It might also suggest actually that in terms of if you're disregarding arrangements, then those arrangements are focused in and around the types of decision which go to the relevant transfer, and that the reason for this is to focus in on that, and that might give some indication as to what sorts of or when and what sort of involvement is required. I think a bit clearer is what's called the avoidance condition. Now that's set out in subsection 5, and the avoidance condition is met if the relevant participator did not object to the making of the relevant transfer, and it's reasonable to draw the conclusion from all the circumstances of the case, the relevant participator was aware or ought reasonably to have been aware of the transfer, and that one of the direct or indirect consequences of the transfer is the avoidance of a liability to taxation. So this introduces what seems to be a second motive defence. Well, certainly a second defence in relation to tax avoidance purposes. Taxation here has the same wide meaning as it does in section 737 of the Income Tax Act. So basically, any tax under the management of HMRC. So that would include, going back to the Fisher case, betting duty. So it covers situations where avoidance of income tax is nothing which anybody is concerned with at all. There are two elements to this. Firstly, it seemed to be an answer to object to making the relevant transfer, to say, well, actually, I object, I don't want this transfer being made. And secondly, this might be an answer to the problems around when do you have to be involved, it must be reasonable to conclude that the relevant participator was or should have been aware of both the transfer and that a consequence of it would have been the avoidance of liability to taxation. As to the first of these, obviously it's going to be an answer to object to making the relevant transfer. One problem which does occur to me there, and which I don't think has been given an awful lot of thought, is that going back to the Fisher case, they had a business which was failing and was going to be worthless in 3, 5, 6 months' time. They were getting a reasonable amount of money for the sale of that business. That was clearly a decision which was in the interests of that company, and which the directors ought to have been saying yes to, because either we can say no and get nothing for the asset, or we say yes and we get 100,000, I think it was. So clearly, in terms of their fiduciary duties to the company, it was something which they ought to have been doing, and they ought to have been saying yes to that. But separately, you have the revenue saying, well, actually, no, in terms of your own personal interests and your own personal interest in not being hit with a penal tax charge, you should be saying no to this, notwithstanding that it's in the interests of the company. And this whole point about objecting to transfers in circumstances where actually the transfer might very much be in the interests of the company, if not in the individual director's own personal interest, does seem to me to create quite a difficult conflict, and something which, again, doesn't seem to be thought through, but again, may provide an issue going forward. It might be, one answer is to say, yes, I'm a director, but I've obviously got a conflict here, so I can't take part in the decision, but just to be clear, I object to it for personal reasons, and query how the legislation would apply in that case. I think it might well be that that's sufficient in order to address the problems and make sure that the legislation doesn't apply. We also have another disregard provision. Again, arrangements which would result in the avoidance condition not being met are to be disregarded. So presumably what that prevents is you flooding the board with lots of new independent directors who take the decision in the interest of the company, while the director who doesn't want to be caught by the transfer of assets and role provisions is taking a step back and going, no, 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 I object to this, knowing that that objection is not going to have any effect. So presumably it's arrangements like that this is intended to impact upon. But again, what is the effect of disregarding those arrangements? Seems to me the transfer is taking place. If you're just disregarding the appointment of various new directors, it doesn't impact on anything. The one director who really cares about it has in fact still managed to say, no, 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 I object. But again, I think that's just a drafting error and something which presumably will be picked up as the legislation goes through Parliament. So that is sort of the legislation itself. As I say, there's an identical provision under section 727A, which applies in relation to the section 727 charge. In terms of commencement, we're told that the amendments have effect in relation to income arising on or after the 6th of April 2024. Presumably, what that's intended to mean is it applies to transfers made before that date, and so it's retroactive in its application. Slightly oddly, it doesn't spell that out, and you might think that actually if that's the intention, it ought to be set out explicitly, and quite often you do see it where commencement provision will say, well, this applies to income arising after 6th April 2024, notwithstanding that any transfer took place before that. But there we are. It's a little bit vague in terms of it. As I said, there is no apportionment provision, which is potentially problematic. Presumably that means that it's all going to be left to the revenue's discretion. Again, I think there's a problem there in terms of section 743 as to, it's open to question what happens where you have 3 shareholders and 2 of them are able to claim the benefit of, say, the avoidance condition. Can the revenue portion the income so that only 33% is attributed to the one shareholder who can't claim the benefit of that? It doesn't seem to me to be entirely clear that section 743 allows you to do that. It allows the revenue to prevent duplication of income. What it doesn't allow them to do, what it doesn't seem obviously allowing them to do, is to say that, well, actually a part of that income falls out of charge altogether. That was an issue in Fisher where one of the shareholders had become non-resident and the revenue had left a chunk of the income out on the basis that she was non-resident. It wasn't in anybody's interest to argue the point, but it always seemed to me that it wasn't clear that the power to do what they were purporting to do. The other point which might arise in relation to associated operations, and I think where that could be interesting is, so you've got a transfer by Mr. A to Company X, which he has a 25% interest in with his 3 children. Company X then makes a transfer, and Company X can be UK resident or non-UK resident, to Company Y, and income arises to Company Y. So there now is a very obvious question as to, well, who's the transferor in relation to Company Y? Is it the shareholders of Company X, or is it Mr. A, who's at the start of the chain? No, I think Mr. A must have an argument for saying, well, actually, we've got this brand spanking new legislation which says that there is a transfer in there in the middle, and therefore I'm not caught in relation to it, regardless of what you want to say about associated operations. Obviously, that's not, well, obviously the other answer is, well, actually, it can be all of them, and the revenue have a huge discretion as to who they want to go after for this money, but that's not exactly ideal in terms of self-assessment and working out who has to return this income. And also, it is a bit constitutionally sus that the revenue would have that sort of discretion as between various people. So I think that's another problem which probably hasn't been thought through as well as it ought to have been. And I think that's a problem with this legislation generally. It's a bit focused in on the facts of the Fisher case. It's not as thought through in relation to the wider circumstances where it could apply. And given that it could apply to a lot of investment companies, the impact is potentially quite significant. I'm worried that I'm right on the time, and James has warned me. So with that, thank you very much.
Good afternoon, everyone. As James said at the start of his talk, there's no need to read the technical note on this new legislation about the remittance basis. All you need to read is the talks by James and Rory. You did, but I assume what you meant, James, was that whilst mine is not perhaps necessary for professional profit at this stage, it is recommended for personal pleasure, perhaps about a year from now when we look back with rose-tinted spectacles, how gentle we thought the new legislation was going to be. But enough about what Labour might do in their budget, inevitably before 6 April next year. I should say, I'm going to look at just some fairly straightforward case studies of different individuals at a very general level, what one might do about their tax positions, because, of course, one of the essential things that one requires before one engages in any detailed tax planning, apart from the brain power of James Kessler or Rory Mullan, it is legislation. And we don't have legislation at the moment, so there's not a great deal of point in thinking about complex arrangements by which we might get the best result from this new stuff. So, first case study is a fairly straightforward one. Mr. or Ms. You may take a pick. Is non-resident, UK non-resident, and never been a UK resident before, but is about to move to the UK next month. Sorry, in May rather, in May 2024, and will be UK resident from then, but won't be domiciled because the intention is just to work here for a few years before returning to A's existing employment abroad. So in 2024-25, next year, A's going to be UK resident for part only of the year, so split year for A, entitled to split year treatment for income tax, capital gains tax purposes. And once A arrives, we'll have to decide whether to claim the remittance basis. That's just all the existing rules, obviously. We've heard some mention of anti-forestalling possibilities. Personally, I have my doubts about what anti-forestalling provisions might be put in place. I think once you start to think through what anti-forestalling provisions might attempt to do, it becomes, I think, kind of impossible to imagine any, at least for me, that might be put in place to reverse the effect of realizing gains or income before A arrives in May, or somehow bring forward. Well, it'd be quite crazy if you see to somehow bring forward income or gains realized in 25-26 into 24-25, could bring those income and gains out of the FIG rules and into the existing non-DOM rules. So I think once you actually get into thinking about what anti-forestalling provisions might be put in place on the basis of this idea, at least, it becomes quite difficult to see what they might be. It just means that assuming this legislation is put in place, which it won't be, but if one were to assume it were, at least these basic ideas would probably not have any problem with it. Choice for A is fairly straightforward. Claim the remittance basis for which there's no remittance basis charge in the year of arrival. Then from 6 April 2025, A is within the new FIG regime. So FIG in 25, 26, 26, 27, 27, 28 are all exempt. The question, what about the following year, 28, 29, obviously looking quite far forward in the future, probably doesn't matter terribly much just at the moment. What the technical note says that qualifying individuals won't pay tax on FIG arising in the first 4 tax years. First 4 tax years after becoming UK tax resident. So does it mean full tax years, or just does it mean tax years including the split year of arrival? Probably 4 full tax years. because the technical note also says that the statutory residence test will be used to determine tax residence for any one tax year, and split years will be ignored. Now, I assume I read that as meaning that any split year is just left out of account in working out whether someone is here for 4 tax years or not. It might mean, of course, that the fact that a year is split is ignored and is therefore treated as a full tax year. But inevitably, the legislation will clarify this, and that's what we have to look at in due course. In any event, that only matters terribly much for A in this example in tax year 28-29, so we needn't concern ourselves terribly about that at the moment. So in terms of planning, assuming, for example, A has latent gains on non-UK assets, then inevitably, ideally, realising before A comes to the UK in the first place. If that's not possible, then seek to delay realising them until 25-26 or later, on the footing that they will then qualify as FIG and be outside the scope of UK tax altogether. But if one has to realise them during the split year of residence, 24-25, in the residence period, then of course they're subject to the remittance basis in the usual way, and the planning just remains as it is currently in relation to the remittance basis rules. As James pointed out, the remittance basis rules are not being abolished by any means. They are just simply continuing on ad infinitum, or I suppose ad mortem, for anyone who is currently non-domiciled or will be UK non-domiciled in 24-25. And the same applies to income, at least savings investment income in the normal way. Employment income slightly different, because what's going to happen to the overseas workday relief is a bit unclear. So overseas workday relief for individuals who UK non-resident come to work in the UK, and for the first 3 tax years, I think it is, income from work done abroad is outside UK income tax through this relief. At one point to notice that what the technical note says at the moment is that to get overseas workday relief from 25-26 onwards, you have to claim for the FIG basis of taxation. Even if you get no other foreign income gains, I think you still have to put in a claim. You'll fill in the box in your self-assessment return to say that you're non-resident for more than 10 years, or in your first 4 years, and you would get the FIG basis if you had any FIG, but you don't, and that doesn't matter. You still need, I think, on the basis of the technical note, to take that box to get overseas workday relief. So that's just a potential trap, again, depending on what the legislation says, to avoid. And again, with overseas workday relief, the technical note is again somewhat ambiguous as to whether that's going to be available for the first 3 full tax years or the first 3 tax years, including year 0 split year, if I can put it like that. So again, just something that will hopefully be clarified in legislation we're never actually going to see. Anyway, yeah, I told this is not for professional profit now, it's for personal pleasure in a year's time. So case study 2, just a slightly different scenario. So a UK non-resident, UK non-domiciled, but has been previously UK resident, and the first Constellation case study 2 is that he or she was UK resident until 10th June 2017. So by the time A arrives in May 2024, A has been non-resident for more than 5 years, as everyone's aware, I'm sure. The point there is that A is not within the temporary non-residence rules for either income tax or capital gains tax, so no income or gains realised in the period of non-residence will be treated as realising on the day of A's return in May, this coming May. A will get remittance basis this year if A makes a claim for it. But, of course, A has been non-resident for only 7 years. And so on the basis of the current proposed rules, won't get the fig basis of taxation from 25, 26 onwards. So we can see that A in this scenario is going to be in a rather worse position than under the current rules. And yes, as I think James and both Rory mentioned, proposals, they aren't just going to have losers, it's winners and losers, but I think James points out probably far more losers than winners, just in the nature of things. In any event, the point there is that income gains that A makes on or after 6 April 25 don't get a new proposed relief. So because A is currently going to be non-dom for the split year 24-25, then either seek to realise income and gains as usual before A arrives in the first place, or in the residence part of the split year 24-25, so that they're before A will lose any benefit, any favourable tax treatment on 6 April 2025. Of course, there's another example then where any acceleration or even ordinary course realisation of income or gains in the split year, or residence part of the split year, will need to be remembered as time goes on, because remittances after that time will still be, after 5th April 2025, will still be brought into the UK tax regime, possibly getting the 12% transitional or temporary repatriation relief brought in 25, 26, 26, 27. That, of course, will have to be looked at closely just to see if the conditions are met. But thereafter at normal UK tax rates. So what it looks like is realise income gains before A arrives, in which before 6 April 25, if they need to be brought into UK, bring them in 25, 26, 26, 27, and not after that. With twists. So let's suppose again, A not a UK resident, non-UK domicile, previously resident until 10th June 2019. So by the time A returns in May 2024, A has not clocked up 5 years of non-residence, and so is within the temporary non-residence regime. So again, remittance basis until 5th April 2025, but not going to be within the FIG regime because not 10 years non-resident. What to do? Claim the remittance basis, of course, because any non-UK income gains, income or capital gains, either side employment income, will be subject to remittance basis. So do that before 6 April 2025. What happens then if they're needed to be brought into the UK after that? Well, it's possible that these will get the benefit of the temporary repatriation regime, but not entirely clear. Because as Rory mentioned, that's only available when income or gains arose to an individual whilst the individual was claiming a remittance basis and was UK resident. So what about income and gains on the temporary non-residence rules? Well, they don't actually arise to someone when they're UK resident, because they're deemed to arise again on the date of return. So will it be enough under the temporary repatriation relief that the income and gains are deemed to have arisen on the date of return, so that they arise when the individual is UK resident and will therefore be within these rules? Again, just a particular point to look for if and when this legislation comes into force. So it depends on how it works. Gains in a non-resident period, income gains in a non-resident period deemed to arise when A arrives and becomes resident in May 2024 may be within the temporary repatriation relief, but may not. And I'm certainly not making any promises either way. So next one is the same as the first couple. The difference between this time A is UK domicile. So we have to change the first one slightly. You can suppose that A has been UK resident before, but not for a long time. Left the UK 30 years ago, whatever. So A is UK domiciled, therefore no remittance basis claim when A arrives back in May 2024. But in the first scenario, so A has been non-resident rather, for more than 10 years. A wins. A wins because despite being domiciled and not being entitled to a remittance basis, A does become entitled to the FIG basis from 25-26, because that doesn't depend on one's domicile status. It only requires non-residence for more than 10 years. And so A, in that case, is better off under the new rules. Planning advice: if you can't realise income and gains before A arrives in May, don't realise anything until the 6th of April 2025. Second and third scenarios, so A has been resident in the UK before, again, either for 7 years or for 4 and a bit years. A is not going to meet the criteria for the FIG rules. So there's not really a lot for A to do. Not non-dom, not FIG. So realise income and gains before you come to the UK. Otherwise, it doesn't matter terribly much. Point there is also overseas workday relief may be lost, but it would have been available now, because of course overseas workday relief depends on making a claim for FIG, and at the very least, even if one can make a claim for FIG without having overseas income and gains, one would at least expect the legislation to require the claim to be a valid one, in the sense that it must be made by someone who is entitled to it if they had any income and gains. So not enough just to tick in the box, you must also have had 10 years non-residence before you can make the FIG claim on which overseas workday relief we are told would be parasitic. So that's that. I should say, of course, the final points. The third scenario for A is temporary within the temporary non-resident rules. Realising income gains before A arrives in May 2024 might not achieve much because they'll be deemed to arise on A's return in any event. So I think I've dealt with case study 3 of the first as well. So case study 4, inheritance tax. This is a case study that I expect a year from now to get the most laughs, because not only do we not have legislation, we're told that this is all up for consultation, and who knows what the outcome of that is going to be. Let's suppose A is UK resident, but not UK domiciled, whether deemed domiciled or actually domiciled. So that's actually domiciled at common law against on the basis of the good old Scottish case of Udney against Udney, or deemed domiciled in the 15 years, I think it is, out of the last 20 years residence in the UK. So, as matters stand, A, liable to inheritance tax on UK assets, not worldwide assets, and can still establish an excluded property trust. Let's supposing A is UK resident since June 2014, so by the time A arrives in May 2024, just shy of the 10 years. A suddenly becomes within worldwide IHT taxation come 6 April 2025, even though A is clearly non-domiciled still at that point. That's a big difference from what the current rules are. Slightly, I'm not sure quite what word is, which isn't a terribly satisfactory concession from the KC, but in any event, this idea of a 10-year tail strikes me as somewhat difficult. Supposing A, having been in the UK for 11 years, leaves the UK and goes to live in any other country you care to mention, the possibility that HMRC will, on A's death 9.5 years later, somehow be able to enforce a claim for UK inheritance tax on all of A's worldwide assets seems to me to be a bit fanciful. It seems that, as James mentioned, the UK has only got a handful of double tax conventions on IHT at the moment, and it's at least currently astonishing to work out why the Indian one is still in force, given the Prime Minister's wife is a non-UK Indian domiciled lady. Who'd have thunk it? Anyway, it seems to me the idea of a 10-year tail is somewhat excessive. It may be that that's shortened a bit before the rule come in. Who knows? Or it may be tempered by the UK having to put in place rather more IHT double taxation conventions than it has at the moment. One question of detail that springs to my mind: suppose A is here for 11 years, leaves for 6, and then comes back. We have A is liable to UK IHT and worldwide assets during from year 10 of A's period of residence. A leaves in year 11, and then is still liable to UK IHT and worldwide assets for 10 years after that. Okay, but then A comes back after 6 years. 4 years later, the tail finishes. But at that time, A hasn't been UK resident for 10 years. A's been UK resident for 4 years. So is there now going to be some gap a 6-year gap until A is once more 10 years UK resident? Or are the rules going to be changed such that if you become resident once again within the 10-year tail, you're treated as basically on the hook, and then onwards as if you had remained resident in the UK up till that date you arrived? I expect legislation to say there is no gap, but again, that's I dare say that's something that will come out in consultation if I've managed to think of it. Certainly HMRC will in due course. So that's, I think, what's all I want to say. Oh yeah, just I suppose one planning point: if a non-dom client already resident in the UK for 10 years, can still make an excluded property trust, of course, but that will be lost on disposes on 6 April 2025. But otherwise, of course, depending on how the legislation actually works, it might be possible for that client once more to make an excluded property trust if A is, as at 6 April 2025, not yet 10 years resident. So if A comes May 2024, non-dom until April 2025, I mean, non-dom forwards, but then the base of IHT tax, IHT switches to 10 years residence, A may still be able to make an excluded property trust until A meets that 10-year residence criterion sometime in 2034, by which time, hopefully, the consultation will have finished. I'm going to finish now, if I may say so, 9 minutes early. Thank you very much.
Thank you very much, Philip. So we have time for questions. We'll start off with questions in the audience, that's with some advantage in coming along in person, and then they will look for questions online. Is it on? I think it's not. I wonder what the button is. There's a button up there. Next, good guy. I'm going to raise my voice if you can't hear me. Yes, I will raise my voice. I just speak with the microphone. Yes, do we have any questions? Go on.
Do you think an income distribution from offshore trusts made in the current year or next year, an income distribution as opposed to a benefit that matched to Rory taking the transfer of assets provisions, might qualify for the repatriation relief in 25, 6, 6, 7?
Yes, I do.
Yeah.
Yes, I think that's what it says. So there's a lot to be said for in circumstances where somebody is not going to get any other ongoing relief. There's a lot to be said for making that distribution this year. So I said, this year in 24-25, in order to get benefit of that relief in the following year. Hopefully, before that final decision is made, we will know a bit more as to what the rules are. The only downside I can see would be the IHT. If you strip out all the assets of the trust by an income distribution up back to an underlying company, which you could do, you are going to lose the benefit of the IHT relief. So there'll be things to that impact, but subject to that, that's what the rules seem to say as I read them. Yeah. No, that is an important planning, will be an important planning point for actually. Yes.
Yeah, I appreciate no one has a crystal ball, but given the fact we don't have proposed legislation even, and we'll go protect the consultation changes to the regime, in your professional opinions, no analysis can take, do you think it is a ultimately, obviously the general election as well, whether under either a Conservative government coming in 25 or beyond?
I think your guess is as good as mine on that. Can we take a poll? Who thinks the rules will run to time and who thinks there'll be a year's delay? All those in favour of saying we'll run to time? That's probably a third. All those in favour of a year's delay? That's another third.
IHT delay.
Oh, well, IHT, yes. Well, let's look at the figure rules because they're further developed. IHT is more likely to be delayed, I agree. As far as the figure rules is concerned, the audience seems to say about 1/3 on time, 1/3 delay, and 1/3 don't know. I mean, and your guess is as good as mine on that. I would, plan so far as one can on the assumption that they'll run to time, but not be surprised if they run late. And hopefully, we will know in time. What happened with our last big revolutions? 2008 was just rushed through without any delay or indeed without any thought at all. 2017 they announced a year or so in advance, didn't they? Yeah. And they did actually keep to their announced timetable. Some of the provisions, as you point out, overran to 2080. Was that was outside? Yes, it was outside the initial timetable. Yeah. So some of it did run late.
I suppose neither of those big changes were within a few months after general election.
Yeah, there's that complication, and these are bigger changes than those. Although those were perhaps you might say involve more complexities, particularly in relation to 2017 when we introduced. Actually, they were both very extremely complicated sets of changes. My other guess on this speculation on this is how many pages of legislation will we have? Over 100, under 100. It could easily be over 100 pages. If you count, I haven't done it, but I mean, if you count the number of times the word domicile is used in tax legislation at the moment in our yellow books, which part out here, every one of those has got to be looked at. It's going to be a mammoth job. Yeah, so maybe we will fall behind. I won't be surprised if we fall behind. I won't be surprised if we stick to time. I haven't answered the question, but that's the only answer I will give.
I think the big imponderable is what the Labour view on the changes is, because if they take the view that, well, that's all well and good, but we want to do it differently, then I would have thought you're going to have a delay while they bring in whatever their version is going to be.
It's not one of those. Yes, that's absolutely true. Now, I don't think Labour thought very hard on reforms. And the reason I say that is because they gave us no details. They said we're going to abolish domicile, non-dom reliefs, and we're going to introduce a short-term residence relief. But now they could sit, if they have the resources, they could sit back and start thinking a bit more, particularly about the transitional rules, some of which are quite generous, well, all of which are quite generous, actually. Yeah. Philip, we got any views on this one?
No, I'm just quickly looking to see, and it seems that word domicile is mentioned 359 times in the old tax handbook. So
only 250.
359.
So only 350 in the
old tax handbook.
In all the volumes.
Apparently,
I would guess more than that, but that's still quite a long schedule, isn't it?
Yes, no. So I think rather there's 359 hits, but
some of those may not be current, or maybe in the comments, or yeah.
Yeah, but each hit has at least one, and some 3 or 4 uses the word domicile. So yeah, probably a good couple of thousand altogether. I
see. Yeah. Oh, I see what you mean. There are multiple uses within one section. Yeah. That would count as one hit.
Yeah.
Yes. Okay. Please.
I think the excluded property protection for pre-April 2025 trusts could be vulnerable in the event of change of government.
I'll repeat the question just in case anyone didn't hear. The exemption for pre-2025 trusts, could that be vulnerable? I might distinguish between those made in 24-25 and those made before. The difficulty with reviewing trusts made before 2025, years before, is that if you introduce new rules, we'll have to say, in relation to trusts made in 1980, what was the residence of the settlor in the 10 years of 1970 to 1980? The records won't be there, will they? So that would be difficult. But they could review just the last year, say this is an outrage, possibly. Again, I mean, I'm afraid all questions are going to be like this, where we're not going to make much progress because I mean, these are important questions which we don't yet have answers. It doesn't, they're important questions, but I'm not going to satisfy you.
Yeah, no,
What do you think on this one?
Once you think through what the legislation have to say and what, so you're gonna say it's good a property trust made by a non-dom, 24-25, who's resident for 10 years already. Then what's the point of saying legislation takes effect from 6 April 25-26 if 10 years rule effectively already counts in 24-25?
Yeah.
I mean, it seems to me to be a bit inconsistent with the notion of fixing the date from which the legislation is going to be applying, just to say, well, actually we're going to apply it 6 months earlier, whenever you have to make a up in 24-25.
You could bring the date forward, couldn't you? They could say, they may be drafting the press release now, from the moment they take power, whenever that may be, either October or January, it seems to be the guess. From that moment, we are going to introduce bring post-announcement trusts into the new regime. If that's right, then we want to do it. Then we want to do something before the election, don't we? That wouldn't be bad advice, I think, for people who are going to create a trust. People have decided they want to create a trust in 24-25 for the IHT reasons. Might be something to be said for doing it sooner rather than later.
Presumably they need to be very sure of the domicile decision.
They'll need to get their domicile right. Yes, well, that's always true when somebody is creating trust, isn't it? Yeah. So you have added problems if you don't actually know where you're domiciled, which could happen. Or if you like to tell yourself you're not domiciled here, but you're anxious that a closer investigation may make that a difficult claim, and I've seen cases like that. Well, we've all seen cases like that.
Yeah, I suppose for sure, if you're going to hit the 10-year residence mark at some point in 24-25, do it before you hit that anniversary.
Yes.
I mean, we're definitely seeing an increase in inquiries into people who set up trusts for the 2017 changes.
You're seeing increased inquiries into, sorry?
So people who came to domicile in 2017 and who set up trusts, for example, beforehand.
Yeah.
HMRC are definitely taking these people.
They're creating trusts before they become deemed dom. So what is there to inquire into?
So HMRC are asking questions which suggest that they think they may have acquired domicile choice earlier.
They say, right, we're not disputing residence because we know that. You can count to 15, and we're not because there may be cases where we're not quite sure whether someone's been 15 years resident. But they're not saying that. They're saying, okay, we'll allow you're right out deemed dom, but you've been here 15 years by definition. Getting on to 15 years, perhaps you've decided to settle here. Yeah, no, that.
Seeing the same pattern. Common or domicile inquiries is people who, for whom it's almost not relevant except that just before the domicile apply.
Yes. And have you seen these?
No, I haven't seen anything from around Consultation or it comes to me after it's come to you.
It is a question of fact, of course, in each case. Did this person settle here or do they intend to go home? And if they say they intend to go home, one, are they lying through their teeth? Two, is it well, so one, is it true? Two, is it fantasy? They say, they say to themselves, well, I'm going to go home, but is it just a dream? Those are the questions. I suppose.
It seems to depend on the age of the article.
Indeed, if they're 92 and they say they're going to go home in 5 years' time, you may find that claim implausible. And those are the facts of the case in which I was advising last week. So it might be 87, I can't remember, but anyway, that sort of age. Yeah, absolutely. If you lose one domicile, you might always come along and say you made the trust by mistake, and try and get it set aside. That's your ultimate hope you'll have to get out, isn't it? And of course, there have been cases like that too. Yeah, I've seen those. I've not actually been involved in them. I think Harriet had one, didn't she? Where they were setting.
Yeah, so yes. I think I provided expert evidence for it.
But did you? All right, well, you know all about it then.
Yeah.
Where basically they decided he made the gift of trust. Later it emerged, I think in the context of divorce, that his domicile, he was domiciled here when he made the trust, and then they set aside.
Yeah,
Yes, no, I think I had that on that as well. Yeah. Not on the set aside application, but on the domicile. How to make yourself unpopular in these sorts of cases is to say, I believe this guy was domiciled in the UK when he made the trust. Still, that's what we're here for sometimes. Yes, please.
Maybe like what is a cleansing facility, like especially somebody who is in like 4 years, they bring in funds, but you know, like the funds are from a mixed account. So they don't bring in everything because let's say some of it is in stocks and shares and other investments. So you know, like would there be a facility to to cleanse them, or would it be in the ratios? Like, what we had in 2017.
Yes. So the question is this: what happens if we have a remittance from a mixed account? Well, the starting point is we have our mixed fund rules, which are complicated, but broadly they say income and gains come first. That's something of a simplification. And then after that, there was some reference, wasn't there, Rory, to tinkering with the mixed fund rules?
Yeah, in terms of the temporary repatriation facility, they've said that they will make them, I think the idea is make them simpler to apply as part of that facility. Whether it's just for the purposes of the temporary repatriation facility or more generally, I don't know. But my reading of it was that it'd just be for the purpose of the 12% charge.
Yes, well, that would be something.
Yeah.
Although actually, if you want to remit, you might as well remit the lot. You may not have such a problem. So the relief isn't going to cost much.
Yeah, I got the impression that because it was going, if you don't know how much foreign income and gains you have,
yeah, we'll help you.
That will help you, so that it might be some sort of simplification, so that you avoid having to do complicated sums to work out
or
bringing in,
or impossible sums.
Yeah. So that rather than being in the situation where you just won't bring it in because it's too hard.
Yes.
What they say in the technical, there will be some relaxation of the mixed fund ordering rules to make it easier for individuals to take advantage of the temporary repatriation facility. If, for example, they've got FIG and mixed fund, they're able to precisely identify the quantum of their FIG.
Yes.
Which one can take to mean that they'll help you ensure that you bring in
they'll help you
basis funds before FIG funds.
Yes. That's true, because because the facility lasts for 2 years.
Yeah, so if you bring in FIG funds,
then yes, and they might come first as under the rules.
In 25-26.
Yes. They have thought about it a bit, haven't they? To be fair to them, they have thought a little bit about these problems. I don't like to compliment it, the drafter, because of what we have to put up with, but it wasn't a bad paper, I thought. I think what you thought.
Yeah, there have certainly been.
Yeah. Brahma, do we have any questions online which we ought to address, and how we're going to deal with them? How many?
13.
1, 3. Can you? Is it possible to bring the computer here, and I can sort of pick the ones which I think are most interesting in the limited time we have?
Yeah.
Sorry, this is the IT we have, because I think a screen in front of me. Would that be possible? In relation to people who are here, even if we don't get to your questions, we have drinks afterwards and another chance to talk. In relation to people online, I'm going to stop on time at 1:15, so we'll just do what we can.
Just in terms of Philip's case study, so I was thinking, if you have a capital distribution, you must be careful not to fall into the trap of not having a split year. And so therefore you'd want the capital distribution in 23-24, wouldn't you?
Yes,
you're going to become resident in 24-25.
Yeah, that's true. Yeah,
that's a very good point. Have you got them there?
Yeah, hang on.
Right.
If James says a very good point, it must be a very good point.
Scroll to your
So it's starting here.
yeah, and then scroll to your left.
Stay there, and no, don't sit just there because you look uncomfortable. Sit down on that seat next to me. And then when I need help, I'll call on you. Question 1: if the interspouse rule switches to a 10-year rule, instead instead of domicile for inheritance tax spouse exemption? Will we need a deemed tenure election instead of a deemed domicile election? Well, the whole rules will have to be rethought, and that might be the way that it goes. Here, I think we probably can wait a bit and see what happens before having to actually act.
I think also the election rules were brought in because of the European Union. That's not a problem anymore. So
they could just abolish them. Yeah. Yes, they were brought in under EU pressure, and now and before they were there, then there was simply a tax charge on interspouse gifts if it was going outside the IFT net. We could go back to that, couldn't we? That would be a simple solution.
Yeah.
Because they're quite complicated rules. A little bit unfair, perhaps, but you could debate that. Yeah, yeah. Please explain how the new rules affect someone long-term resident, 20 years, who is non-dom but deemed dom. So we have a UK resident, non-dom, deemed dom. This is a transitional point, really, isn't it? Because
well, I suppose deemed dom means you've got no remittance basis.
No remittance basis anyway, and no fig relief.
Yeah, 20 years means no fig.
Yeah, so the only thing this client can get is transitional relief. Does he get transitional? Oh, sorry, there are various transitional reliefs.
There may be sort of unremitted income or gains offshore, which
that's right.
Are subject to the same
Can we get
rules
some more
as everybody else.
questions?
So that would be, I think, potentially subject to the transitional repatriation relief if the money was brought offshore. My reading certainly of the transitional repatriation relief is that it's not limited as such. It applies to any income in relation to which the remittance basis is previously applied. So whichever regime you got that under, I claim 12%.
Yeah, I think the technical note doesn't put any time limit on it in the past, so it's not a standard I'd expect. So they'll get repatriation relief. Yeah, it's also being careful as to which foreign income and gains you bring in.
Here's a very good question. Offshore trusts have survived previous tax changes. But is this the beginning of the end for offshore trusts post the enactment of the legislation? Perhaps it is, do you think? For those who come here and for settlers who come here and stay 10 years, these offshore trusts will come within the scope of tax.
Well, one thing which occurred to me about, and this is on the different bit which I was talking about, the transfer of assets abroad changes, is that they make it significantly less advantageous to have a company or an investment vehicle going forward. And so, for example, using family investment companies where the shareholders can now get hit quite clearly with the transfer of assets abroad charge, that becomes problematic. And one obvious answer to that is to use a trust instead. So swings and roundabouts as far as offshore trusts go. Some ways less advantageous, in other ways they will have advantages.
Yes,
but that's always been the case, I think.
Yes. But certainly, if one of the attractions of trust traditionally was get your, if nothing else, you get your inheritance tax excluded property going forward, that may go. Although another effect may be that people want their trusts and they leave before they clock up 10 years. So the trust will continue, but not for you long term, not for UK settlers. How are we doing for time? It's now past. I'm sure there are lots more good questions on online, and I'm simply going to not going to answer them. But because I think it's more important we go out and have a drink and start drinking while we can. Please stay if you've got a few minutes, and I hope you enjoyed the seminar. Good. Thank you.
Stop shares.